This video covers key topic number 4 in our workshop, protecting your assets in case you have to go into a nursing home. Again, I recommend watching these topics in order. This video focuses on understanding wills and probate.
Key number 4 to saving your assets and creating an estate plan is understanding wills and probate. If you die without a will, your stuff will go the way the state says it goes. That's what's known as intestacy. The thing is, that can often be a surprise to many people. For example, in Kentucky, if you die with an asset titled solely in your name, then approximately 1/2 of that asset will go to your spouse, and the other half will go to your adult children. And that surprises a lot of people because so many people just assume that it would go all to the spouse. So a will at least lets you set forth who is going to get your stuff when you die. And it also lets you name who's going to be in charge, your executor. But a will only controls what you own in your own name when you die, and a will has to go through probate. The problem with going through probate is there are a lot of disadvantages to that. It does occur with or without a will. It's a legal process, so you have to follow all the state's rules. There's a delay. Usually a probate estate has to be open a minimum of 6 to 9 months. All of the control for the probate case is with the court, not with the family. It's a court proceeding, so that means it has public access, and all the personal information is there in the public record for anyone who wants to look at it. And it can be expensive. The AARP estimates that a probate can end up costing between 5 and 20% of the value of the estate.